Okay, on to my next topic area, which is on unfair prejudice, and we'll start off with Coolc and Interfish. Now this involves a company, N, which was created following allegations of illegal or so-called blackfishing by the predecessor company. Now the court went into some detail about what blackfishing is. I understand it's the under-declaration of catch in order to frustrate quotas and HMRC. So clearly N was a company with a bit of history. Now N had 3 directors from Interfish, the majority shareholder, 2 directors from Coolc, the minority shareholder, which included Director A. Now the shareholders' agreement contained various reserved matters. Nothing unusual in that. What was perhaps more unusual is that it included the fact that Coolc's consent as minority shareholder would be required for the commencement of proceedings. Now, Coolc was not in a good place. It complained of not being able to participate in the management of N, and was not happy with Interfish's threatening of proceedings against A and Coolc for breach of duty and breach of warranty dealing with legacy issues from the predecessor company. So Coolc issued an unfair prejudice petition as a minority shareholder. Now Interfish, as the majority shareholder, brought a counter petition based upon the conduct of Coolc and the alleged breaches and the inability of Interfish to get Coolc's consent to take those proceedings. Now just pausing there on section 994 of the Companies Act 2006, those are the provisions that relate to petitions for unfair prejudice. Again, I'm not going to read through that. Take your time to read through as you wish. I just refer you to subsection 1 and the fact that it refers to a member of a company applying to court for a petition for unfair prejudice. It doesn't distinguish between a minority shareholder, a majority shareholder, or indeed any other shareholder, and that's important for reasons we're just about to see. Coolc's case foundered and the petition failed. The court was satisfied that N was not a quasi-partnership and it did not have a legitimate expectation of participation in the management of the company. The sting in the tail was that Interfish's petition succeeded, even though it was the majority shareholder. Due to that shareholders' agreement, Interfish's voting rights were not aligned with its shareholding, thereby disrupting its ability to manage N. The court also found that the conduct of A as Coolc's nominee director could be attributed to Coolc for the purpose of section 994. So what did the court do in relation to the finding? Well, it has a wide discretion under section 996 subsection 1. It provides that the court may make such order as it thinks fit for giving relief in respect to the matters complained of. And if you look at the second bullet point there, those are some of the many things the court has power to do. Now, whilst in many circumstances a share exchange may have taken place which leaves Interfish as the sole shareholder, in fact on this occasion an inquiry was ordered against A and Coolc, and that was effectively what Interfish was looking to achieve from the very outset.
So Stuart, do you think that's an indication that majority shareholders will petition for unfair prejudice more often?
I think it's unlikely. A majority shareholder usually is in a position to remedy shareholder conduct through the use of its voting rights. It just wasn't possible here due to the restrictive shareholder rights that favoured the minority shareholder. So I think this is probably not a case that's going to be indicative of a wider trend, but it just shows the majority shareholder does have the right, just like a minority shareholder, to petition for unfair prejudice.